Chocolate. I'm calling to order, I would like to call the order the August 14th, 2025 Planning and Zoning Board meeting and ask the city clerk's office to call the roll so we can establish quorum.
Chair Fitzgerald,
Here.
Vice Chair Robarts,
Here.
Board Member Hayes,
Here.
Board Member Edmondson,
Here.
Board Member Clements,
Here.
Board Member Grant,
Here.
Board Member Cardenas is absent. Chair, we have a quorum.
Okay. Please stand and join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we have, I need an approval for the agenda. Are there any additions, deletions, or modifications to the agenda?
I make a motion, we pass the agenda as read.
Are we doing the thing on the streets? Wasn't there? Am I?
Oh,
Agenda.
okay,
Agenda.
Okay.
okay. So, all those in favor? I didn't get an official vote.
There wasn't a second motion.
Okay, I need a second motion.
A second to the motion. Anybody seconded the motion? We have the motion. We
to
need a
approve the
second.
agenda? Okay.
Oh, I'm sorry. About the resurfacing of the driveways is on our agenda. Previous impervious
Impervious
surface
is
in
then
driveways.
postponed to the next meeting.
Never mind if I read the whole sentence. I'm sorry.
Yeah, no problem.
Okay.
Okay, so
Pass
the
agenda.
motion passes for approval of the agenda. We need to now have approval of the minutes from the June 12th, 2025 meeting.
So
Are
moved.
there any changes?
So moved.
So moved.
Wait,
All right, so I
just
have-
one. I'm sorry to be a minute.
Okay. Thank you.
I'm here for a reason, right? It said something about, I can't find it right now, it said something about passing out information on that conference. We didn't get any information. I don't know how particular you want to be on that. You didn't pass anything out last,
I announced the
Announced it.
workshop, but we
Yes.
didn't pass out, because we didn't have the flyer or anything, but I guess in the minutes it says something about
Yeah.
passing it out.
Well, it says we gave information, so that's the oral presentation.
pardon?
It says Ms. Malone gave information to the board, so that's the oral presentation.
So hearing, no more, okay, can I have a motion then to approve the June 12th minutes?
So moved.
Second.
Okay, approved and second. All those in favor, say aye.
Aye.
All those opposed, say nay. Motion passes. Time now for me to open the next items for public hearings. Item 1, Resolution 2025-34, a designation of administrative official for plat and replat, which I had to look up because I couldn't remember what plat was. In accordance with section 177.071 Florida statutes, and a city initiated resolution for compliance with the section 177.071 Florida statutes by designating an administrative official to approve plats and replats. Presentation by staff. Ready?
Yep, thank you, Chair. So this item, it's really just one of the state statute changes that affected us that we're pretty much processing for the continuity of our development process. So essentially, effective July 1st, as the title read, we have to have an administrative official review and approve the plat, not the governing body. So this change essentially effectuates that through the code, and staff does recommend approval.
So the planning board won't be seeing any plats coming through. They will be processed administratively with staff.
Okay, doesn't it say something in here that the state, I'm not sure if I'm saying that right, is that the state will have that authority, but you have to have a local authority also?
No, so the state pretty much outlines the process that the plats have to go through, and before they would go essentially to the governing body, which is the city council, and then you all would make the recommendation, but the state law now makes that all administratively. So the Department of Development and Neighborhood Services would be the reviewing body and the approving body of the plats. But then they would still have to comply with the site plan that goes in front of you all.
Okay, because in section 177.071, it states each local government is designated by ordinance or resolution to administratively authority and official responsibility for reviewing, processing, and administratively approving plats and replats.
Correct, so this
Only
is
after the
this.
state has done it?
No, it's essentially that state law changed July 1st, 2025, outlining that this new process has to go administratively here. So the state has no purview over the platting process of the local governments.
It wasn't before. Is it?
The only
the
change,
Ordinance changed something within our,
so this resolution is making that change where now the administrative review would go through our department instead of going to city council. So this is what that resolution is.
all right, thank you.
I have a couple questions. First one is, under the new process, so how will the public be notified of plat and replat approvals handled by the administrative officials?
So currently, the only change to the process is that instead of city council, it goes administratively, but the things that go into a plat, it's more so the site plan. The site plan that comes in front of you all is where you really do get that public comment on what that is. But the plat is truly just the layout that is recorded for that property.
But that, you're saying the staff is doing all the approvals, it's not, no longer coming before the public or the board or anybody from the public at all?
With the controlling document being the site plan that shows the layout of the property, shows the layout of the building, the parking, almost showing the details that would be on the plat still do come in front of you all, and then that plat has to correspond to the site plan that you all approved.
Okay,
So the plat is a very technical document, very specific things as to what it has to show on a plat. So that's why I think the state usurped and said no longer does it have to go through a public hearing process or to a governing body to approve it. It needs to be done administratively because it is just looking at checking off that they meet those technical requirements.
all right, so, next question, is there an appeal process? If whatever they brought to you, you deny, is there an appeal process? Because you're approving it, right? So if you can approve it, you can deny it.
So ultimately, there's an appeal process for almost any development order, and generally this one would go to circuit court if it was appealed. There's other appeals that go in, either to city council or the next body, but this one, that's how the code reads.
Jenny, would anyone who's an abutter, for instance, to a piece of property be notified so that they would be aware that this is happening and could file an appeal if they chose?
So for our code criteria, there's no mailing required for what this is, and that's currently, so the only change is we're complying with state statute, and this resolution allows us to comply with state statute so that we're not allowed to bring it to the city council, so we will no longer bring it to city council, and it has to be an administrative body, which here is Development and Neighborhood Services.
Right. So just like what Gianni was saying, the approval of a project would come before you as a site plan, and that site plan lays out the development. A plat is just the last step of providing for the legal lots of record.
Okay.
So it's administrative, it's really a technical document in nature. The plat would be required to be consistent with the site plan. So you will see the site plan, council sees the site plan, that's where the public hearing process comes into play as well. So plating is really just an administrative technical review to make certain that the layout of the lots is accurate, correct. It indicates all of the easements, the dedications, all of those types of things. So it's not really changing or taking a decision away from an already, governing body. It's putting it back in an administrative approval process. And it's what the state mandates, so we're complying with the state mandate.
My question was, I just wanted to avoid any appearance of secrecy.
Yes,
Do you know
no,
what I
it's
mean?
definitely, yeah, yep.
Are there any other questions or comments from staff? From here? Okay, I will open the public hearing at this point. I'd like to open the public hearing for this item. Are there any people out there that are from the public that would like to speak? Seeing none, I open okay.
Close.
Seeing none come forward to speak, I will close the public hearing. Do any board members have any other comments or discussion on this item at this time? Hearing no further discussion, I need a motion to approve 2025.34, the resolution, and a motion.
I move to approve.
I need a second.
Second.
Okay. All in favor, say aye.
Aye.
Opposed, say nay.
Aye.
Nay, okay.
Oh, no, I mean,
Motion passes. Item 2.
Postpone.
Well, the item 2 is postponed till the next meeting, so we will go to item 3. Mixed-use development dash office, MXD-0 update, a city-initiated request for a zoning text amendment to provide updates to the mixed-use development office zoning district for consistency and establish non-conforming provisions. Presentation by staff.
Thank you, Chair. So with this one, this is a city-initiated zoning text amendment to the Division 15 for the MXDO district. So this amendment, it establishes the specific non-conforming provisions to address the certain legally established uses that existed prior to the MXDO being in existence, and then prior to some of the amendments to MXDO. So essentially, this clarifies that lawfully established single-family residences on properties less than a quarter acre can essentially continue as they are and do the repairs and do maintenance, and also clarifies that if they're destroyed, that they can be rebuilt. This is one essentially just a housekeeping item to clarify this aspect of it. We are discussing it with legal, but essentially, if those discussions are to proceed with this would allow us to bring it forward to council. This would address some of the issues currently that there may be some concerns with purchasing and financing. So if needed, we have these provisions ready to address that.
Question?
And as an alternative to what we're seeking right now.
I have a question. Go ahead.
Is this relevant to the person who wanted to sell their house and could not sell it because the area was not zoned appropriately?
Yes,
Whatever.
but that situation is that they currently have MXDO, and it doesn't allow, our non-conforming section doesn't allow rebuild or expansion, well, I should say expansion of a single-family home. If it is destroyed by natural disaster or something like that, there's a provision that allows it to be rebuilt.
So will
So-
this clarify that for the person?
Yes, this is an alternative that's being presented more from a timing perspective. We have an alternative that's being pursued, and it is based on our existing non-conforming language. I think there might have been some confusion as to whether or not even in a natural disaster situation would you be able to rebuild the single-family home. And it's the single-family home that currently isn't an allowed use within MXDO. So, but we are seeking an alternative. The language that's in the code today, we think, recognizes for those natural type of disasters. And so we're seeking an alternative that may not necessitate this language change. But if we find through what Gianni was saying with legal, that alternative is not one that's going to be pursued, then this language would be appropriate. And so from a timing perspective, we want to bring it forward to you. And then in the next few weeks, we'll know which option of the two will be pursued.
Something is in the works to resolve it so these
Yes.
people can
Yes.
sell their house?
Yes, the current language, I think there was. Mhm.
I have a question. You said that the MXDO zoning district resolution, whatever, does not allow for single-family? And how is it that these designations have single-family units on them?
Because when it was rezoned, at first it allowed single-family, and then sometime subsequent, the city redid the uses within the MXDO. So MXDO is mixed-use development office. So it's really looking to have a mixed-use development, so you wouldn't be looking for a, single-family home in that kind of scenario. So it's looking at an area and what you want is a vision of that area for the future. So as is typical with with zoning regulations, there are these non-conforming provisions that speak to those situations where when the rezoning took place and there was a use that was there that doesn't conform with the in this case, the MXDO uses, it allows for that use, in this case, the single-family home, to continue to be in that category, to be in that zoning district. What it doesn't allow you to do is to expand it or change it into a more robust, use. The idea is for at some point for that property to conform with the uses that are allowed in MXDO. So it does allow for, and that's why you see the single-family homes are still there. The question arose, if the house was destroyed, would they be able to rebuild the single-family home?
The verbiage was very,
So.
very, very convoluted.
Yes, so that's been clarified, and also working with, their appraiser, making sure that they got those provisions correct. And I think there was some confusion that, oh no, you couldn't do anything with a single-family home. You just can't enlarge it or continue to increase the nonconformity. But if it was destroyed, hurricane, fire, you could rebuild back to what you had. You just can't enlarge it or make it, more.
Why is it that it's such a small area, small size of a quarter of an acre for the,
Because I was gonna say, that entails like where we are working with the gradual transition of the properties, because for the MXDO to actually build out, whether it's, the mixed use site with residences and office, it normally entails larger than a quarter acre. So if someone is going over time to assemble these properties, it may take some time. So that's where the quarter of the acre really lends itself to a different situation versus a property that's, almost an acre and can just, that sole property be developed by itself.
how does a residence like this conform to those things if it becomes a business, if it becomes commercial, and it needs more property? And it's already, I can just see someone, using this property in the commercial, in the mixed, in a mixed business situation, and yet they can't make it any bigger?
No, they can, and that's where the code is almost entailing them to get it bigger, but it's, as you have the single-family home right now, essentially the single-family home, like Denise said, is being transitioned out based on how the current code reads. There's actually no provision to allow you to do repairs. It allows you to rebuild it to the original height and footprint of the house, but unless it's destroyed, you can't do repairs in the meantime. So those are also the aspects here specific to MXDO, trying to clarify those pieces.
Kind of reminds me of the Up, you know, where the house was in the middle of the city and he wasn't going to sell and he was allowed to stay. I mean, and, you know, not improve, just stay the way he was.
Right.
Is that kind of what you're saying?
That's exactly it,
Okay,
yes.
the
So the
Community
properties,
could build around them.
right, so anybody who has MXDO, we know there, for instance, there are some properties that are for sale in the MXDO. A neighboring property may sell and there may be somebody who comes in and develops it as MXDO. So the idea is that over time, the area would become, all of it would become MXDOs, but it allows the existing uses that were there at the time of the rezoning to MXDO to remain until such time as they do transition to become an MXDO.
Could it evolve to a more residential area, not necessarily commercial?
No.
It's mixed-use office is what the vision is and what is desired to be for that area, for those areas that are already zoned as MXDO.
No, not really.
So that would not be something that, you know, the code
Unless they got it
speaks
rezoned.
to.
Well,
They'd
and
have to rezone.
And in the example of the CNC Legacy Plaza that you all saw, I think late last year, that's a little over 0.7 acres. So that kind of gives you where you can still have, you know, they have 3 office bays towards Jog Road and 3 townhouses in the back, still meeting the intent of what MXDO is.
I actually walked to see this area. And it's right off of Jog Road, and it should be a business area. I felt really bad for the people when they presented at city council. The more I thought it over, now is not the time to be dealing with it. Apparently, when it was rezoned, 2015 maybe, or 2008,
2014.
that was the time for them to have complained or whatever it was, and, you know, whatever.
And therein is the rub, because I don't think that these people are being told enough. I don't think a letter from the Green Acres is enough to let them know that their property may be worthless. You know, it may be worthless. They're gonna be that Up cartoon. They're gonna be in the city
Yeah.
of a complex thing. I don't think they're being explained. I think we should certify letters to people that this involves. It's only 3 people in this situation.
Yeah, and just the property does have worth to it. It depends, you know, I think what their buyer was looking for, they didn't want a condition saying that, you know, regardless of what happened, whether it was natural disaster, if they destroyed their house, or if they wanted to make it bigger, larger, they wanted to be able to do that. So that was their discretionary decision as to whether or not they chose to buy that
talk to the
property or
buyer?
not. So,
You talk to the buyer? Because that's not the story.
okay. I'm just saying in general, that's
okay.
exactly what
Not
came
the
back, because we've
specific one.
seen the appraiser, you know, what they said, and we've spoken at length to the current owners of the property, so.
Okay. It's hard when you're close to the situation.
Yeah, ultimately, it's what the buyer, you know, chooses, so. But at any regard, getting back to this item, this is, you know, a possible alternative, and again, as far as expediting in terms of time, we wanted to bring it forward to you. We will let you know if it actually is the choice, the alternative of choice, and it goes to council. Otherwise, the other option will be pursued, so.
You know, I could see where, if they choose to hire an attorney, I mean, you know, this is a single-family house. So say that they, in their mind, think they could get $400,000 or $500,000 for this house. If it can't be occupied properly, then maybe they could only get $100,000, you know, if they want to sell it as a. So these people, if they're litigious, this could go on for a while.
Yeah, and I just want to be clear that The property currently can continue to be operated as a single-family home. There is nothing in the code that disallows that.
They can
It
sell-
does restrict if they want to increase the square footage of the house, if they want to expand the current nonconformity, which is the use as a single family.
But they can still sell it as,
They could sell it as single family and somebody could move in as a single family. So again, it goes back to the buyer and what they
buyer.
choose to accept in terms of the restriction that's on the property. But it can be continued to operate as a single family. That's what the nonconformity provisions are for. It allows for that. But it, also in looking at wanting to transition to MXDO, it has some limitations on, expanding or enlarging, the structures on the property.
Look, can I make a suggestion? I suggest that one of my colleagues up here make a motion to approve it, however, with the condition that redevelopment triggers such as change in use or redevelopment of the site be clearly defined in the code, and that any reconstruction be required to meet current safety codes while preserving original height and density where possible. And I think these protections should remain in effect for current homeowners regardless of future MXDO updates. That's my suggestion to my colleagues.
I like it. What do you guys think about that?
Can you say that again with the,
All right, so,
because I'm just trying to see if the non-conforming principles already cover.
so my suggestion is that we approve it with the condition that redevelopment triggers such as change in use, that's the language we're talking about, redevelopment of site, let it be clearly defined in the code, that any reconstruction be required to meet current safety codes while preserving original height and density where possible. And I think these protections should remain in effect for current homeowners regardless of any updates or changes that you make to the MXDO.
Okay, so any redevelopment would have to conform to the MXDO code and the
Right.
uses therein.
Okay.
So they wouldn't necessarily stay with the existing building, which would be the existing density or height.
All right, so we'll take out redevelopment.
So I think
Well-
you're,
Well, in the sense of, so that actually kind of leads into the next item on here. So development is already defined in our code, and it's almost any action of anything that really needs a permit to do is development. But you have the exceptions here about now we're also accepting the repair, the extension, and the modification of the structure as long as it is in compliance with that MXDO. So I think I understand where you're going, and I think it's actually being addressed in the language that we're proposing here. So
And then what about so the protections stay in place for the current homeowners?
unless they do
Regardless of any change.
No, so that's where the change in use is where you're switching from a single family home. You have to switch to something that is permitted in MXDO. So these are the triggers that would essentially now you have to comply with the MXDO.
Right, but they're protected, the current homeowner is protected as it stands, regardless of any change.
But that's really the trigger. So the change in use, the redevelopment, the site and development plan. But otherwise, we're saying that they can keep their existing home, they can make repairs to their existing home, they can keep their existing home as long as there are none of those things, which are the change in use or the redevelopment to another type of property. So in the sense of, there's a doctor's office on the west side of Jog Road that was formerly a house. It went through the site and development plan process. It went through the permitting process to establish itself as a medical office. You cannot convert that medical office back to a house now. So that's essentially what that trigger is.
Okay. And then how are the homeowners being informed of any change in?
This isn't the only section that we're talking about that has these codes, right? And has
yeah,
homes on it and stuff
nonconformities
like that.
are, yeah.
Citywide. So nonconformities are citywide. Some districts have special sections in the district about nonconformities. The MXDO did not have that, so this is where we're adding the specific ones to MXDO to address the situation that you all are aware of.
I think what we're looking for is protection for the current owners as well as, you know, protection for the city, but
Yeah.
to make sure that the current owners and future owners are protected and notified.
Yeah, so the single-family homes have their protection through the non-conforming provisions.
All right, so when a change is made, are they informed?
Well, they would actually have to be the ones authorizing that change as the property owner. We wouldn't allow anyone else to come in here without an owner authorization
No,
and
no, like
apply.
updates to the
MXDO.
MXDO, like a change is made, we agree on the change, are they informed?
So we've been working with the property owners through making this language. Any future changes, that actually is kind of already addressed here, where we're saying the MXDO or any amendments there too. So non-conforming is non-conforming, whether it's because of what we changed now or whether it's non-conforming because of what's changed 10 years from now.
And any of those changes would come through the public hearing process, so it would be, you know, it would allow for public input to be put on the record and whatnot too, so.
All right, I'm okay.
Is this ever a cause of eminent domain in that this,
No, eminent domain is if there's total, you're,
bought out and you're.
yeah,
it's-
and there's no
okay,
more
so-
use of your property because it's being totally converted or used for, you know, public purpose, so, yeah, that's a totally different. At any rate, so again, this is one of the alternatives, we may not go through final with this, where the alternative of, the existing language in a zoning confirmation letter of such is, what we're seeking as well, so, but in essence of time, if that alternative does not, lend itself to come to fruition, we would be looking for this to go through. So in essence of time, we wanted to bring it forward to you tonight, and get your vote on this
So,
that's
but
being
it's not,
presented.
it's not, you said you're still working on legal language. How can we
No,
adopt something that's?
the alternative to this, it won't affect the language that's in here. The alternative to it is what we're working on, and we're pursuing that as our primary means of addressing this issue with
What
the
does that mean?
homeowner.
What is your alternative?
The zoning confirmation letter with the language we have that allows for the rebuild of the single-family home if it's done by a natural disaster.
Okay, all right.
So do you need us to pass this in order to move on with?
We would like to get your recommendation on it, so in case that we do need to go forward, to proceed to council, then we don't have to bring it back, because that takes an extra period of time for that to happen.
I have a question. So I'm going to have to need a motion to approve ZTA 25-07 as written now. That's, okay.
That's what staff is seeking, yes.
So moved. So moved.
So moved, okay. But I have to
Yeah.
open the
Gotcha.
public, okay. I do not recognize you until someone up here said that, sir,
It-
from the public. Okay,
We'll
you are
just
part of
open it
the-
up to the public
yeah,
hearing and
so,
then.
I
Has
don't
taken
know
its
that
test
I'm
yet.
gonna say that, you know, I open the public, hearing and close the public hearing, because I didn't think he was going to respond or talk, but I have to give you that if you want to go ahead and say anything. So I will not just not give him a chance.
Good job.
Okay. So I need a motion to approve ZPA 2507 so we can vote.
So moved.
Second? All in favor? No, I need a second.
I second.
Okay. All in favor?
Aye.
All opposed?
Nay?
Motion passes. Item,
I'm sorry, that was Ms. Hayes' nay, right? Okay,
I'm sorry, I should have.
just for the record, thank you.
Okay, item 4, 25-08, study area zone, SAZ. A city-initiated request for a zoning text amendment to update the framework of the study area zone, SAZ district, so that would be study area zone district, and allow minor improvements while properties remain under the SAZ designation. Presentation by staff.
Thank you, Chair. So this is a city-initiated zoning text amendment to Division 13, which is the study area zone. So this one, the study area zone, it serves as a temporary holding zone for properties that have been annexed or they're undergoing long-range planning studies, and essentially it allows us time to actually recommend what the permanent zoning district will be for the property. So as of right now, if you are in a study area zone, all development is prohibited. There's no development that's allowed in a study area zone. We would like this amendment to clarify that if you have a site plan or a development order or annexation agreement that already contemplates development on it, that you can actually continue with that development while being in the study area zone designation. Also in this, we're clarifying that certain things to address public health, safety, welfare, to address if there was a code violation, for instance, if landscaping died off and you had to replant landscaping, if the fence fell down, you have to put the fencing back. Right now under our code, that's considered development. So we made exception for minor improvements similar to that, landscaping or fencing, really the main ones that come to thought. But otherwise, the language here is essentially just to clarify that you can do the development that's already essentially been approved, and then you can make those minor improvements in the study area zone.
Okay, I always have a question. Does this refer to the land in back of Aldi, that big lot?
So actually, right now, we don't have any designated study area zones, but looking at the future annexations that we're
Or I meant, yeah.
Yeah, looking at the future annexations that we're looking at, for instance, we're looking at potentially going to Lantana and Haverhill. That area may pertain to having a study area zone designation. So it's to keep the intent of the study area zone, but allow the flexibility if you already have previous approvals or if you need to essentially do property maintenance.
Question, what is the definition of minor improvements? Because what I think is a minor improvement may not be a minor improvement to you or vice versa.
So in the sense of what we have improvement defined, minor improvement is actually to the discretion of the Director of Development and Neighborhood Services, who is essentially doing the permit. It's hard to define what those improvements may entail, because if you have a 30-acre property, you know, even in the sense of what minor is, it may be that there was a storm came through and you have to re-landscape the site, or, you know, so what minor improvements are,
Gray area.
so, yeah, so the type, it's really, like we were saying here, landscaping and fencing are really the ones that come to mind, but otherwise, they do have to essentially meet that, where it's really for the protection of public health, safety, and welfare, or to address a code violation.
So it really speaks to more, minor is more of the type of improvement versus the quantity of it.
Okay.
So you wouldn't be able to increase your uses or things of that sort. It's really to allow, because right now you wouldn't be able to do anything. You wouldn't be able to augment any landscaping, you wouldn't be able to do any fencing. It would be for those types of things versus putting up an additional building or development that would be, you know, more substantial than.
Because even in our definition for development, you have demolition. You can have a building that's unsafe now that needs to be demolished. We're almost saying that you couldn't tear that building down because that was under development.
Makes sense.
And this is just, in the SIZ is basically a holding pattern while you're looking and seeing what zoning is most appropriate and what you would like for those sites. And they are usually those that are annexed, and they might have a county approval for something, and we don't have a current zoning district that accommodates that, and we're trying to, work something out and to see what development we would want on the site and do an appropriate zoning for it. So it's kind of a holding pattern.
Is there a size restriction for a zoning for this
No,
kind of thing?
yeah.
I mean, it could be an acre lot, it
Yeah,
could
it
be
doesn't
5
have
acres,
any
it could be
size.
50? Okay.
Yeah.
Are they usually habitated? Are they usually structures on them, or are they usually vacant?
Yeah, it's case by case. So the history of the study area zones, like it's really the properties that we annexed, and they were either completing their process through the county and then coming through us essentially for permitting, or they were kind of in some form of limbo. So this would allow them to continue.
All right.
Any further questions from staff? Okay.
That's good.
From them. So I will open a public hearing. Sir, if you have any questions, you can come, otherwise, okay. I will, seeing none, I will open the public hearing and close the public hearing. I will need a motion for us to vote on ZTA 25-08.
So moved.
And a second?
Second.
Did you get that? Okay. All in favor?
Aye.
All opposed? Okay. Motion passes. If there are any other discussions that you would like to have, yes?
No.
No? Okay.
And then so we just have two announcements. No discussion items, but two announcements. I do want to introduce our new Planning and Zoning Board member, Aldo Cardenas, the alternate.
Thank you for being here this evening. Yep. He. Yes, he's finishing up all of his ethics and all of the training stuff that he needs in order to actually be seated at the dais. So, thank you for coming. Then the only other item we have is I had announced the planning commissioners or board member workshop that originally was scheduled for August. It's been postponed until November, which is why you haven't seen the flyer yet. I actually haven't even gotten the flyer yet. So we will actually be letting you know of that and highly encourage everybody to attend. It will be in Jupiter. It will be a day long, and city will cover your registration fee. And then we have just our next meetings would be September 11th, October 10th, and November 14th.
Oh,
Um,
wait a minute, can you,
That's
I got
not
that
what
right.
I have on my paperwork, but September 11th, October 10th.
Mm-hmm.
Okay.
Right, second.
'Cause I received October 9th as a date and November 13th, but it.
Oh, actually, it is October 9th. Sorry about that.
Okay.
no, wait a
And the
minute. you said
13th, I'm off the day. I was
September
giving you a Friday,
September 11th,
October 9th, November 13th.
November what? Still
I
30.
looked too quick on the calendar. And that's all. Thank you.
Anything else? Otherwise, I will adjourn the meeting.
Excellent, thank you.